Welcome back to the bench. I'm Judge Lisa, and this is case number 4. In my entire career, I have never presided over a case where the law itself seemed to fail the moment the verdict was read. This is the story of a perfect murder, where the killer was neither a psychopath nor a greedy villain, but a ghost. A mind wiped clean by a chemical so new, our legal system literally had no name for it. The case was the State versus Damon Frost. The clickbait headlines called it the designer drug defense. I called it the death of legal precedent. The defendant, Damon Frost, was a phenomenon. At 31, he was an Oscar-nominated actor, the darling of every glossy magazine, known for his intense method acting and his equally intense public parties. The victim was Elena Reyes, a promising film student and an acquaintance of Damon's. The setting was Damon's ultra-modern Hollywood Hills mansion, a place designed for spectacle and excess. The crime was brutal. Elena Reyes was found dead in the mansion's infinity pool, not drowned, but killed by a severe blow to the head, suggesting a violent confrontation near the water's edge. Damon Frost was the only other person present. When police arrived, he was found wandering the grounds, incoherent, wearing clothes soaked in water and blood. He offered no resistance, no plea, only a terrifying, empty stare. The initial assumption was alcohol, cocaine, or a simple jealous rage fueled by celebrity entitlement. But the toxicology reports came back stunningly clean, save for trace amounts of a substance labeled only as compound Z18. The state crime lab had no classification, no known toxicity profile, and certainly no Schedule 1 or 2 designation for it. This was not a street drug. It was a chemical ghost. The prosecution, led by the formidable Marcus Chen, faced an immediate, paralyzing hurdle. They had a mountain of physical evidence: Frost's blood-soaked shirt, his DNA under the victim's fingernails, his singular presence at the scene. But they lacked a legally recognizable motive or intent. Damon Frost claimed total, absolute amnesia of the entire night, not from alcohol, but from Z18. This was the opening the defense exploited, turning the focus from who did it to what was responsible. The defense team, led by a silver-haired legal shark named Victoria Cross, was quick to introduce the designer drug defense. She didn't dispute the physical facts. She disputed the criminal mind, the mens rea. Her argument was simple. Damon Frost lacked criminal intent because Z18 placed him in a state of involuntary, chemically induced psychosis, rendering him no more responsible than a sleepwalker or someone suffering a sudden stroke. We spent days immersed in pharmacology. The prosecution called experts who described Z18 as a novel psychoactive substance, a compound tweaked in a lab to avoid current anti-narcotics legislation. It was designed to mimic LSD and PCP, but with a molecular structure just different enough to be legally invisible. It was, literally, a designer loophole. The defense then brought in Dr. Leena Sharma, a neuropharmacologist. Dr. Sharma's testimony was the pivot point. She explained that Z18 doesn't just intoxicate, it binds to unique receptors in the frontal lobe, essentially deactivating the part of the brain responsible for impulse control, moral reasoning, and the formation of short-term memories. In a controlled dose, it produced euphoria. In an unknown dose, which Damon Frost, the careless celebrity, had clearly taken, it could induce what Dr. Sharma called automatic destructive behavior. Crucially, Dr. Sharma testified that Z18 was not only undocumented, but had a paradoxical effect. While it caused psychosis, it was so novel that the current legal definition of voluntary intoxication did not strictly apply, as Frost could not reasonably foresee the exact effect, given the lack of public knowledge. The law, I realized, was stuck in the past, debating a chemistry that was already 2 years ahead of us. The debate narrowed to one legal razor's edge. Was the intoxication voluntary? If Frost willingly ingested the drug, he was liable for the consequences. If Z18 was so unpredictable that the effects were unknowable, did the law still hold him responsible for a psychotic break he couldn't have predicted? The defense argued Frost was a victim of his own lifestyle, but the prosecution pushed back hard, claiming this was the ultimate celebrity cop-out. Marcus Chen, the prosecutor, cross-examined Damon Frost for an entire day, attempting to pierce the amnesia. Chen: Mr. Frost, you state you don't remember striking Elena Reyes, but you remember taking Z18? Frost: I remember being given something. I remember the high. And then nothing. My mind is a void. Chen: a convenient void, wouldn't you say? You have no memory of the crime, but you have a perfect memory of being handed an obscure drug by a shadowy associate, conveniently absolving you of all guilt. Frost: I have no memory of anything else. I would trade my career to remember, Mr. Chen, but I cannot. The true tension came when the prosecution introduced a witness, Damon's personal assistant, who testified that Damon specifically asked for something new, something extreme, just hours before the party. This proved premeditation in drug seeking, but not premeditation in murder. The jury had to decide if deliberately seeking extreme intoxication was legally equivalent to accepting responsibility for homicidal psychosis. This forced us into a philosophical crisis. Was the act of seeking the chemical high the moment of intent? The emotional toll of this case was crushing. Elena Reyes's family sat in the gallery every day, watching a legal system try to define away their daughter's killer based on a chemical formula? As the judge, I couldn't lean on precedent. There was none. I had to instruct the jury on an entirely new legal paradox. I spent 72 hours drafting the jury instructions, knowing that every word would set a precedent. I instructed them that if they found that Z18 had a known, established risk of violent psychosis, Damon Frost was responsible for his voluntary intoxication. But I had to instruct them, if they found that the drug's properties were so novel and unknown that no reasonable person could have foreseen the homicidal effect, they must consider the possibility that Frost was incapable of forming intent. The key to their verdict lay in the meaning of unknowable. Damon Frost was, by all accounts, highly intelligent, but he was also reckless. Was his fame his shield or his ultimate undoing? The jury was out for 5 grueling days. I watched their faces when they came back, a mixture of fear, resignation, and moral exhaustion. When the foreman read the verdict, the courtroom exploded, not guilty of murder, but guilty of a lesser obscure charge, reckless endangerment resulting in death. The jury had compromised. They rejected the defense's argument that he lacked all responsibility, but they accepted the chemical argument that he lacked the specific intent required for murder. The public and the press saw it as a massive legal victory for celebrity privilege, but it was, in reality, a technical defeat for the prosecution. I knew the sentence I delivered would be scrutinized globally. I sentenced Damon Frost to the maximum penalty for reckless endangerment, 15 years in federal prison, with the stipulation that he undergo mandatory, intensive psychological treatment centered on impulse control and substance abuse. It was a severe sentence designed to acknowledge the death of Elena Reyes, but it could not erase the truth that he was legally acquitted of her murder. As Damon Frost was led away, his face showed a brief flicker of confusion, then relief. He had beaten the charge. His career was over, his freedom gone for a decade, but he was not a convicted murderer. That day, I learned that the speed of chemical innovation will always outpace the speed of legislative action. The designer drug defense had not just freed a Hollywood killer, it had exposed a vast, terrifying loophole in our justice system, a chemical ghost that we are still fighting to define and defeat. That is the indelible crisis of case number 4.